Good morning.
Good morning.
Can I ask who this is, please?
April Wright.
I'm sorry, who?
April Wright.
I'm sorry, you said April?
Yes, April Wright
Okay,
with the W.
thank you. And what are you on there for, please?
Landlord and tenant.
Okay. Is this for the stay of eviction?
Yes,
Okay, and you are the tenant, correct?
yes.
Okay, I've just renamed you so the judge knows who you are. I'm going to put you back into the waiting room until we get all parties. Okay?
Okay,
Thank you.
okay. Thank you.
Oh, you gotta lower your volume.
Yep. Come on, man. Good morning, Miss Wright.
Good morning.
Still don't have an attorney from Rossville yet, so can you tell me what's going on with your diversion program?
I have yet to receive a payment. Um, when I talked to the front office or whatnot, they stated that when the people who were paying for my rent sent out the payment through mail, they said that they sent it to the main corporate instead of them. So
Yeah,
I
which
guess
agency are you working with?
the eviction diversion program or something like that.
Yeah, but which agency?
Say that again. The
Which
thing people.
agency?
I don't know.
Okay, so they're telling you that they have sent money on your behalf to Rossville.
Yes.
But the management you're dealing with hasn't seen it yet because it went to the home office.
It went to the main office. Yes.
Okay.
So
All right. Well,
they said that they know that she sent it out. We're just waiting to receive it. That's basically what they told me. But I don't know how long that was supposed to take, because when I got the email from the lady, she stated it takes 7 to 10 business days. So, and that was kind of over a month ago.
so that's way late.
Yeah, way late. So I don't know what's going on right now. I'm
All right.
asking
Well,
it. So
yeah, here's your lucky day. I'm tired of waiting for these attorneys. Everybody was supposed to be in this meeting for this case at 8:15. It's now 8:48. I've already called the office once and told them I was waiting for them. This case is dismissed. Merry Christmas.
Thank you.
You're welcome.
Have a nice day.
Doesn't mean they won't refile it. You understand that?
Okay.
So hopefully the agency's money comes through and it gets you straight with them.
Yeah, hopefully. Thank you though, because I didn't want to get in trouble for that.
Yep. Good luck.
Okay. Have a nice holiday.
I'm gonna start my. I think that might be those attorneys that you wanted me to get a hold of this morning for the motion. Yeah.
Security.
Hey, if I don't catch Rich, the cleaner, before he leaves, tell him to make sure he talks to me before he leaves.
Okay, sir.
Thanks.
For some reason, though, she didn't give me a copy of it. I already printed it, and that's not your fault. All right, bye.
Hey, Paula,
Yes, Judge.
see if you can get a hold of Shannon and ask her to come in.
I'll call her. Maybe she's in Mariah's office. I'll go out and look for it, Judge.
Thanks.
Morning, Judge.
Good morning. Waiting for Mr. Knappman to come in.
Okay, we're nice and comfortable, so we're ready whenever the court is.
Thank you.
Judge, her office is dark, so I'm assuming she's not here today. Good morning. Oh, hi, Cheryl.
Good morning, Mr. Knappman.
Good morning. How are you, Judge?
Excellent, excellent. So gentlemen, why don't you officially put your appearances on the record for McGahee versus Zubik?
Your Honor, my name is Guy Vining. I represent the defendant, Tracy Zabik.
And you, go ahead.
And good morning, Your Honor. John Knappman, P42983, on behalf of the plaintiffs.
They'll squeeze it in.
Or
All
plaintiff.
right, so just to make sure we're all on the same page,
Is Mr. Gonick ready to call in?
we've got a default judgment that was entered on December 14th. No,
No.
entered on
Does he have?
November 5th. No, that's not it either.
No,
I had it earlier
November-
today. There it is. Yep.
18th.
I'll give it to
Yep. For possession. And then Mr. Vining has filed a motion to stay the eviction.
you.
That's correct, Judge.
That's my understanding.
Okay. So the motion says reason for the stay is because there was no rent charged, which I'm not sure how that's important when this is just a termination of tenancy for possession.
It also says denial of due process, Judge. And the reason that we're asking the court for relief under MCR 2.612B, because my client says that she was never served a process of the summons and the complaint. The situation is a little odd in that Tracy and her husband, her husband's now deceased, live in an outbuilding on their in-laws' property. The mail comes to the main house at, I think it's 28900. What's it? Prescott Road. Tracy doesn't get mail to her, what we call the bunkhouse. She lives in what's called the bunkhouse. It's about 100 feet away from the main house, where years ago, the property owner built a little apartment on the second floor for the farmhands to live there. And so Tracy says that had she known about the eviction proceedings, she would have answered the complaint. I've reviewed the court's record. She's had a couple different cases, and she's been through landlord-tenant cases before, Judge, and she knows that if you get a summons, you get a complaint, you go to the lawyer.
Right.
Well, in this case, she thought she was coming to see me about a probate matter. We were going to commence proceedings in a probate case. And then around the same time, she found the eviction order taped on her door. Tracy is handicapped, Your Honor. She doesn't drive anymore. She has a dreadful eye condition where her doctors at the Kresge Eye Clinic have determined that she's legally blind. But still, had something come to her attention, she's got magnification equipment that she could read it. She just never received it, Your Honor. So the other part of this that I've discussed with adverse counsel is that we're not sure that the plaintiff in the case is the proper plaintiff. We're informed that the plaintiff is bringing this case pursuant to a power of attorney. I've not seen the complaint, but I would think it would be entitled that she's bringing the case in a representative capacity. And my client says that her father-in-law, William Zabik, who lives in the main house, seems perplexed that he's told her that, you know, it's not his intention to evict her. So we have this family dynamic, and to complicate the matter further, Judge, there are about 30 pieces of farming equipment that was owned by Tracy's deceased husband at Bradford, and that's why we're doing the probate. And now we hear from Mr. Knappman that his client apparently is taking the position that, oh no, we own the farming equipment. So we'd like to resolve that in the probate court, and we're going to file an inventory, and I'm going to send Mr. Knappman a copy of the inventory so that he can see the whole list, and they can object to it if they want, and then we can have a hearing on possession. But in the meantime, it's just our thought. Tracy doesn't want to Tracy doesn't want to stay where she's not wanted. If they really want to evict her, but during the winter time and with all the farm equipment, she just has nowhere to go. So,
All right.
we
Mr. Vining, let me interrupt you just for a minute. Would it help at all if I put you and Mr. Knappman in a breakout room?
it may.
Have you had conversations?
I don't think it would at this point, Judge.
Okay. All right. Well, let me do something else then. Let me interrupt you on this one. I want to get rid of an attorney whose file I just dismissed. So let me bring him in real quick, tell him what happened, and I'll get back to you, fella.
Thank you, Judge.
Okay.
You're welcome. Counsel, your appearance for Rossville Woods.
John Mione for the plaintiff, Your Honor.
All right, and this is on case 203630, defendant's name April Wright.
Correct, and plaintiff will be dismissing this matter without prejudice, Your Honor.
Too late, I already dismissed it because you guys were late.
All right, well, apologize for that, Your Honor, and looks like there was no harm done this
Just
case.
counsel, do me a favor, just send the message. When we send out the notice and says we want everybody in the room 15 minutes before the scheduled date, that's everybody. Because I would have defaulted a defendant that didn't show up after 35 minutes, and I will dismiss on the plaintiff.
I understand that, Your Honor. I will let
Good for the goose, good for the gander. And Ms. Wright did tell me that her agency has told her they've sent money to Rossville, but it sounds like it didn't go to local management and went to corporate.
Okay, I appreciate that, Judge.
All
I'll
right.
let our office know.
Merry Christmas.
Thank you, Judge.
That one is ready, thank you. All right, back to you fellas, I'm sorry. Go ahead, Mr. Vining.
So, Your Honor, my client has had conversations with the homeowner, and again, he says that he's not the motivating force behind the eviction. I've also had the privilege of talking to another farmer that lives in the locale. His name is Brian Van Washtanova. And Brian has told me that he's had similar conversations with Mr. William Zabik, that my client's sister-in-law is the person that's motivating the eviction. He's not necessarily keen on evicting his daughter-in-law. And so when you add it all up, we have a situation where I don't think there's a good record as to who the plaintiff is. And also because Tracy did not receive the summons and the complaint, I think it's clear under the court rule that where the defendant's not personally notified, that the court has discretion to set aside a judgment and the order of eviction. And that's what we're asking you to do. We would note for the record that no third party is going to be prejudiced. And so we would ask that this whole thing be reset, that the present judgment and order of eviction be set aside, Your Honor. And if in the meantime, we're happy to sit down with Mr. Knappman and his client if they ever wanted to do that, and to try to make arrangements. But right now she's got 2 large dogs. She's got all this farming equipment. She's got nowhere to go. And that's why we felt that we had to bring this to the court's attention.
Okay. All right, Mr. Knappman, your response, please. Oh, and just so the record's clear, there is no order of eviction that's been signed yet. We just got a default judgment in the file. Just so we're clear on that.
Well, I thought.
Go ahead, Mr. Knappman.
So, yeah, I was under the impression that, yeah, there was the default judgment. First of all, as to the service, I've been billed and I don't have a proof of service in the file in my file, but I was billed by A. Hinman / N. Jones court officers for service on Tracy Zabik on 11/6 on this case.
Let me weigh in there, Mr. Natman, if I can. I do have a proof of service in the file. I looked for that. It's service by attachment, and Mr. Hinman is in and around the building this morning.
Okay.
I've sent him a text, see if I can get him in here, because the proof of service, I understand there's some confusion about the main house and the auxiliary building. That's not clear on the proof of service. So I wanted to ask that question of Mr. Hinman. If nothing else, I can try to get him on the phone. But I just so we're all on the same page of what the proof of service says and does not say. Go ahead, Mr. Natman.
Well, and let me double check. Yeah, actually, that is for the 890 address on Prescott, which is the bunkhouse. The actual house has a different address, right? And so, so the proof of service is for the address where she's living.
Well, I understand that's what the paperwork says, but I just want to confirm with the process server that he didn't hit the main house and,
Right.
But go ahead. That talks about the one issue. The other issue is the meritorious defense.
Is the what?
The meritorious defense. If I'm going to set aside a default, I'm looking at two questions. What's the reason that the action was not taken?
Okay.
And number two, does the defendant have a good defense?
Well, I can
So
tell
Mr.
you
Vining,
this.
I think Mr. Vining's argument is we got the wrong plaintiff.
Well, I have a power of attorney that that this is the daughter, Mr. Zabek, the owner, along with his wife, live in the house. He's 92 years old. And
Right.
he has confirmed to me as recently as 2
Almost.
days ago that he wants Tracy out, and he wants her out yesterday. And he denies the issue of the farm equipment.
See if you can find Al. I sent him a text. He's not responding. I need Al.
They're gonna call in a few.
Okay. All right. Well, then obviously we're getting conflicting messages from the senior Mr. Zabek.
Well, he's 92 years old, and he's afraid of her, according to what I've been told. So she shows up at the house, he's gonna tell her whatever she wants to hear.
And that may be, so maybe we got to have him show up for me.
What's that?
Maybe we got to have him show up for me so I can hear from him.
I can have him
The
call
pro-
into the court for this
Yeah.
hearing.
The problem with the power of attorney is the power of attorney only gives the daughter the right to do what is in the best interest of the
Right.
father.
And
So
I'm
if the
telling
father
you-
says, yes, I want the property empty, then I think the power of attorney is effective at that point.
Right.
But
And
if
I'm
the father
telling you
says, I want to
yes.
leave her there, right.
And the only thing we have that contradicts that is the defendant saying, well, I talked to him and he told me maybe he doesn't, and her friend. And
Yeah, it's a classic he said, she said. Yeah, classic he said, she said. That's why they put certain people in black robes to make decisions.
Okay, well, like I said, if you want me to, I can arrange to have him call in. Not sure if it can happen in 5 minutes or 25 minutes.
Understood.
Wait,
Understood.
I'd have to be there. He gets confused. This is not.
okay, so I can do that. We'll just have to pass on this and come back to it.
Okay. Mr. Vining?
Would Your Honor want the testimony of Mr. Van Washtenova as well? I guess what I'm
No, because
suggesting.
if Mr. Zabik Senior tells me that he does authorize his daughter to pursue the eviction, and Mr. Washtenova says, well, that's not what he told me a week ago, it doesn't matter. If I hear from Mr. Zabik, he wants to pursue the eviction, and I'm convinced that he's speaking what he wants, not what somebody's making him say, then 20 witnesses that said he might have had a different opinion in the past doesn't really change anything.
I understand, Judge. You're right.
All right. Mr. Natman, what are the chances of getting the elder Mr. Zabik in front of your Zoom camera?
I'm not sure he's able to travel like that.
How are you accessing Zoom right now? Are you on a
I'm in my
laptop? Are
office.
you on your cell phone?
I'm in my office.
Okay, but I understand that, but what electronic equipment do you
Oh,
use
I'm
to
on my
Zoom?
laptop.
Okay, any reason you couldn't take your laptop to Mr. Zavik Senior?
I do have 3 things this morning. One at,
No, not necessarily right now.
yeah,
We'll pick a date that's convenient for Mr., I mean, he's 92 years old. Let's work around his schedule.
yeah. Well, I'm saying I could do it this afternoon if you want. I'd rather get it done today, like 1:30.
I know I can't do 1:30 because I've got some stuff scheduled this afternoon. I'm looking at my calendar. Mr. Viney, can you do the same?
Look at my calendar, Judge? Sure.
Please. I could probably do something around 2:30.
Well,
I've got a landlord tenant docket starting at 1:30 and another one at 2, but I'd probably be cleared up around 2:30 or shortly thereafter.
I have a longstanding appointment with a cardiologist today, Judge, at 4. So I don't know that that would work for me if we got in the queue and Your Honor wasn't able to get to us for a while. So,
Well, it won't be till 4 o'clock. How far do you have to travel to get to your 4 o'clock?
it's in Gibraltar. It's probably about 10 miles.
All right, so if I can make sure you're off Zoom before 3:30, that gives you enough time?
Yes, Judge, it would.
I can do that. As long as I've got both attorneys and the elder, Mr. Zabik, ready to go
Okay,
at 2:30, I'll get you in. Even if I have to stop something, I'll get you in and out before 3:30.
at 2:30 today, we'll dial back into the court.
Mr. Natman, you think that'll work?
Is there Wi-Fi at your dad's
No,
house?
no Wi-Fi.
Oh, they don't have Wi-Fi, so we'll have to phone.
That as long as you can.
Yeah,
Well, I want to see Mr. Zabik.
Yeah.
I don't know Mr. Zabik's voice. I don't want a phone call.
Thanks.
okay. I don't know that. The problem is, like I said, he's 92 years old and they don't have Wi-Fi in his house. So
Okay.
it's gonna be
Well,
a problem.
let's just do it this way. I'm setting aside the default judgment. I'll send out a notice for a hearing in the future and we'll go from there.
Thank you, Judge. Appreciate it.
Because at some point I'm going to have to hear from Mr. Zabin. So I'll give you some time, Mr. Natman, to figure out the technology, how to make it work.
Well, then let's do it this afternoon and I'll figure it out somehow.
All right, 2:30, Mr. Vining?
Yes, sir.
Okay, see you then, gentlemen. Thank you.
Thank you.
Bye.
John Natman.
This thing's always going. That's why I don't like doing it on Polycom. I can't control it. Do you have any idea who John Trummer is?
Yes, that is the special prosecutor on this case.
Mhm.
And Mr. Gonick was in a debt, but she's telling him now, so he's going to be signing on in just a few seconds.
And I don't understand this. Juanita got a notice for a meeting that for tomorrow or for today, or is that a typo?
10:22.
Oh, so she never got anything for the
Right.
meeting last week.
This is what she texted me. So I just tried to put in there what she texted
Okay.
without her
Okay.
anger put in there.
All right, so Juanita didn't get a notice for last week.
No,
Dawn
but she
did,
was called
Jackie did. For last week?
for the 17th. She said she spoke right in there. I have both Lawson and Hitchcock called her to let her know that there were only 2 plants. And
Yeah, did they invite her to the meeting? That's what this is all about.
that, it didn't say.
All right.
Do you want me to call her and
No.
find out?
All right, so Al and Melissa did not get a meeting. We don't know, notice for the meeting. We don't know if Juanita did or not, and nobody got the form. Okay.
Michelle did. She filled it out and faxed it back. And she got an email.
Yeah, okay.
And Juanita said that she got it because she faxed it back to the city. You want me to
No,
show that?
I got it.
Okay.
All right, thank you.
To membership, how many people they have related.
Good morning, gentlemen. Appearances on the People versus Kenneth Parker, please.
Morning, Your Honor. May it please the court, John Trummer, P75097, appearing on behalf of the people.
Good morning, Your Honor. Ben Gonick appearing on behalf of Mr. Kenneth Parker. Your Honor, I apologize for not having a shirt and tie on. I didn't know that you were going to.
No problem.
Okay.
No problem at all. All right, so Mr. Gonick, you filed a motion. You want to address bond for Mr. Parker. Just so we start off on the same page, I'm looking at the file. It looks like the bond is 1,010,000 cash or surety or 10%. No, cash or surety, correct?
Correct.
No 10%?
Correct.
Okay, and I don't see any additional conditions.
Correct. Probably the arraigning magistrate thought that bond, there would be no need to put additional
Probably.
conditions.
Okay, all right.
May I
Go ahead,
proceed?
sir. Now, I just want to make sure we all start on the same information.
Okay. Your Honor, I think normally I don't get into the facts of a case at a bond hearing because of the presumption of innocence, but I just want to point out a couple things. The Reader's Digest of this case is my client come across one of the complainants at a gas station who needed a ride home. He gave her a ride home, went in the house. The allegations are that he demanded money or sex. The complainant indicates that she voluntarily had sex with him. When he left, there was a skirmish that developed. There was another gentleman at the house named Daniel Hopkins. He allegedly hit Mr. Hopkins in the head with a gun. Mr. Hopkins ended up stabbing Mr. Parker in the chest that resulted in Mr. Parker being placed in ICU for a few weeks. Mr. Hopkins was charged with either assault with intent to commit murder or assault with intent to do great bodily harm less than murder. When Mr. Parker was released from was at the hospital, a warrant was issued and he was charged and the current bond was set. Mr. Parker does have 4 prior convictions, but they stem from one incident. It was an incident that I believe happened in 2008 in Washtenaw County, a larceny from person, fleeing for an eluding, a couple counts of fleeing and eluding, and maybe 1 count of obstructing. And as a result of that, he did serve time in prison. What we're asking for in this case is a reasonable bond with a 10% provision. I would respectfully request that Mr. Parker be given a $10,000 10% bond. There is an individual by the name of Jessica Brown who would act as a third-party custodian for Mr. Parker. Any danger to the community could be minimized by placing him on house arrest and electronic monitoring by the Wayne County Sheriff's Department. And I think all those conditions would assure 2 things. One is that he would appear for court when he's supposed to, and 2, minimize any danger to the community that the court may have, or any concerns that the court may have in that regard.
Thank you, Mr. Gonick. Mr. Trummer.
Judge, just to respond to that version of the facts in this case, it's alleged, defense counsel makes it sound like this third person who was staying with the victim of this sexual assault was somehow the instigator of this. Harrison does get a ride home from Mr. Parker. Mr. Parker then demands money when she doesn't have any. He demands it of the person staying with her, who happens to be her cousin. He's in town for a funeral. He then pistol whips and points a gun at her cousin, tries to rob the cousin, and when he doesn't have any money, turns to her and says, well, you're going to pay me with sex. The fact that she at that point does not physically resist him is not her voluntarily having sex with this man. This man has a gun and he's robbing everybody in this trailer. If she has sex, quote unquote, voluntarily, it's to de-escalate the situation and under threat of force and coercion from this gun that's been produced. The fact that later Mr. Hopkins responds and they get into a tussle when Mr. Parker is trying to leave this trailer after having finished raping this victim, Ms. Harrison, is beside the point when we're considering Mr. Parker's danger to the community, especially given the fact that his defense counsel indicates he has priors for larceny and fleeing and eluding and obstructing. I think that shows his predisposition to not participate honestly in this process and shows that he is a flight risk. So he's both a danger to the community. He's alleged to have committed several violent felonies, armed robbery and CSE first degree. And he has a history of, let's say, defiance of the criminal justice system. The core rules allow for remand in cases of CSE first degree, and I think the bond is appropriate. However, if the court is willing to reduce the bond, or then the people would, of course, request some additional restrictions be put on the bond, including but not limited to no contact and GPS tether up to house arrest, I think would be appropriate in this case.
Judge, can I briefly respond?
Yes, sir.
The reason I attached the police reports is so the court wouldn't just be taking my word for it, the court could take the complainant's word for it. I believe in the investigator's report, Michelle Harrison, the alleged complainant, is the one that indicated she voluntarily had sex with Mr. Parker. Wasn't my word, it was her word. I just want to point that out. I also want to point out the evidentiary issues that are going to come up at the exam when I believe it's in January, late January, early February, is Mr. Hopkins, who's one of the complainants in the case, is also charged with assault with intent to do great bodily harm or assault with intent to commit murder. It's going to be interesting to see how he's going to proceed to testify when he has Fifth Amendment concerns, as does my client. And finally, before I be quiet, if you look at the investigator's report that's prepared, even the detective said that Miss Harrison was very I'm using a word my son uses, sketchy about the details. She just kind of just disclosed what she wanted to disclose. And when they asked her if she wanted to go get treatment, she said no. That's all I have.
All right. Mr. Goddick, I'm a little bit curious as to why the arraignment was in August, and here we are 4 months later before anybody makes a bond argument. I'm just curious as to what's changed since August.
Well, actually, we did make a bond argument earlier, and that's why I brought it back before Your Honor. When the pandemic, when this has been a unique process for us all, but at one of the probable cause conferences, I believe the court had received a DSU. And I moved for bond, and you read the DSU, and just to be candid with the court, as I have to be as an officer of the court, the DSU report recommended no action. Unfortunately, in this situation, as his defense counsel, I don't get a copy of the DSU, so I don't know what information they relied on other than his prior criminal history and the allegations in this case. I do know from my experience in dealing with the defendant screening unit, they're not provided all the police reports, which provide candor to maybe some candor to what happened, nor is it really their job to analyze it and be a lawyer. The charges, if you look at the offenses, they are serious offenses. But when you cut through it, there's an untold story here that's going to be told at the exam. And I suspect a lot of the charges will be dismissed as duplicative, and maybe even the capital offense will be reduced.
All right, Mr. Trummer, anything else?
Just for clarity, since we're talking about the investigator's report, it says, while Harrison did not force her down on the bed, did not point the gun at her, and quote, she volunteering took her clothes off and had vaginal sex with Parker, that paragraph ends with, she further explained that she thought by having sex with him, he would leave. She was not certain at this point whether Parker would shoot her or Hopkins. So I just want to be clear that this is not that the force and coercion will be very clear in this case once it comes to the proof.
Okay, thank you, gentlemen. Mr. Gonick, for better or worse, when we send cases down for pretrial services review, at least my philosophy is, they've got a fuller picture than I can ever get short of having a trial or an exam. I'm gonna leave the bond exactly the way it is. Good luck, gentlemen. Stay safe.
Will you enter an order to that effect, Your Honor, in case Mr. Parker wants to pursue it downtown, so I have something to show that I brought it before you?
I just entered an order. I just said it on record. If you want a paper order, send me one.
Okay, that would be great.
I'm not drafting an order for you, Mr. Gunn.
Oh, no, I understand. I'll submit the order. I mean, I'm sure you have
Yeah,
enough
no
to
problem.
do. Okay,
No problem.
Thank you, Judge.
All right.
Okay,
Thank you, gentlemen.
thanks.
Stay healthy and Merry Christmas.
okay, bye.
So I think if how do I do this? If I kick the Polycom out,
I can also mute it from here.
no, I don't want Polycom, Paula, because
Oh, I can
I
turn it
can't
off. then.
control my meeting with Polycom. So I'm gonna kick Polycom out.
I'm here.
How you doing, Mr. Vitar?
Good. How are you, Lieutenant?
Fantastic. What do you want first? We have three. They said you got two?
I got two so far.
Yeah, we got three altogether. There's Coleman, Parker, and Herdman.
I got Coleman and Parker so far.
All right. Herdman's a domestic.
Herdman requested, or Herdman waived MIDC.
Okay. All right.
So
That's
it's-
why. Okay.
Yep.
Okay.
Thanks, Andy.
Yep, I'll get you in a breakout room.
Thank you.
What do you want first, Dan?
Whoever you got, they're ready. No matter to me.
Good morning, sir.
Morning. Just with
Good morning, Dan.
Morning, Judge. How are you?
Wonderful. Which one would you like to start with?
Doesn't matter to me. I was just talking to Mr. Coleman. I guess we can do him first if he's still in front.
Good morning, Damien.
Good morning, Your Honor. How are you?
Better than I deserve, Damien. Thanks for asking. You got anybody up front? We'll start with them.
This is Mr. Coleman. Good
All right,
afternoon.
good morning, Mr. Coleman.
Morning, sir. Judge.
Mr. Batari, your appearance for Mr. Coleman, please.
Good morning, Your Honor. Daniel Batar on behalf of Mr. Coleman, P62191.
All right. So Mr. Coleman's got 4 files with us. We've got a drove while license suspended, revoked or denied from June 17, 2014, $954 due. From April 22nd, 15, we've got a speeding ticket with $480 due. From October 21, 14, a drove while license suspended, revoked or denied with $1,068 due. And then we've also got a December 14, 2015 domestic violence charge that he's in probation status of, or violation of probation status on that one. What can you tell me about Mr. Coleman's situation, counsel?
Judge, he was pretty much homeless for the past 3 years. He was living home to home. He claims he finally has his life together. He has a girlfriend. They're living together in Macomb County. He works part-time at Sheena's Market. And he's hopeful that you'll give him a chance to let him out so he can get back to work. It sees that paperwork shows that he has a couple of different warrants, one out of 33rd District Court and another one out of 27th.
What are they for, Mr. Batar?
The one out of 27th District is a failure to appear for sentencing on a DWLS offense from 2015. And the 33rd District Court case is an active warrant where he failed to appear for an arraignment, Judge. I do not know what that charge is.
Mr. Coleman, do you know what that charge was?
No, sir. This is my first time hearing about it. That's why I'm lost.
Okay, all right. How about a good address for you, sir?
Good address is, excuse me, sir. Remember the address? I just moved. I just gave it to the officer. Is it in the court? I don't have the paperwork with us. I just gave it to them, but it's a new address.
Okay. Who is that? Is that Lieutenant Hull he's talking to?
Yeah, if you give me a minute, Your Honor, I'll be able to pull up his booking information.
Yeah, thank you. How about a phone number, sir? Can you give me a phone number?
That too. I just got a new number and new everything. I got everything together. So
All right.
That's
all right. That's all right.
Do you have your girlfriend's phone number?
Yes. That number is in file too. It's on my phone. We just got our numbers together and everything. Like that's why I'm anxious to get out.
That's all right. So you're working, how many hours a week are you averaging?
I say like I wake up at 6 o'clock in the morning and I get off at 3. So it's like part-time. And then I get my father's social security check.
Yeah, but hold on, slow up. That didn't answer my question. Are you working 10 hours a week, 20 hours a week, 30 hours a week?
10 hours.
That's all you're working?
Yes, that, and I get my father's and I get $1,300 a month.
Okay. But why aren't you working more?
Because I'm just not on my feet and now we're just trying to save up for a car so I can get a better job. Because where I live at is like in the middle of nowhere. There's no buses, no nowhere. So I was thankful to get this job. So we're just saving up money so I can get a car. So that's why I'm so anxious to get back out to work.
Okay. Well,
All right, I've got an address if you're ready.
Go ahead. Thank you.
11906 Spring, Spring, Brook, Brook Court. And that's in Bruce Township.
Bruce, like the man's name?
Correct.
Zip?
48065.
And do you have a phone number?
I do. 248-977-7943.
7943?
Correct.
Thank you. All right, give me just a minute, gentlemen. All right, I hate to do this to you, gentlemen, but let's pass on Mr. Coleman. Let's talk to Mr. Bitar's other client, Mr. Parker, and then we'll get back with Mr. Coleman. I'm trying to check some information out so we know where we're going with this.
Okay.
Just bear with me, Mr. Coleman. Good morning, sir. Mr. Bitar, your appearance for Mr. Parker, please.
Daniel Bitar, on behalf of Mr. Parker, Your Honor. We'll waive a form reading, stand mute, please.
Thank you. All right, for Mr. Parker, we're looking at a probable cause conference date of December 30th. And Greenview Avenue, a good address, Mr. Parker?
Yes, sir.
643-7643, a good phone number?
Yes, sir.
All right. Mr. Bitar, what should I know before I set bond?
Judge, the complainant in this case is his ex-girlfriend, who is also the mother of his child. This incident happened allegedly back in July of 2020. Since that time, they're not in a relationship, but they do communicate regularly regarding child care. So this was an out-of-custody warrant. Mr. Parker was not aware of it. Yesterday, the complainant came to his work, and there was an argument or some type of dispute over child care. The police were called. They saw the warrant for Mr. Parker. That's how he ended up in custody. He works at Ooze Wholesale in Oak Park. He does packaging there. He works 6 days a week. He lives on his own on Warren and Southfield in Detroit. He's 28 years old and he has a GED.
All right. If you know, Mr. Bitar, was Miss Grafton the complainant on any of the prior DVs?
I do not know that, Your Honor.
Mr. Parker?
Yes, sir, she was. And I'm actually want to call the police. I call the police and I go to jail.
Okay. So you've got, other than this charge, you've got 3 DV convictions on your record. Were those all involving her?
Yes, like they all involve her, but like I say, I call the police and I go to jail. Like I called the police yesterday. She came to my job.
How many children you got with her?
Yeah, we have one, but she have a daughter that I help raise. But
All right. And how old is your child with her?
my son, he just turned 4, November 30th.
Okay. All right. All right. Mr. Bitar, anything else before I set bond?
Judge, it sounds to me like they've been in a long-term relationship where they continue to have issues. But for some reason, they continue to stay together. Because of that, and the fact that this incident was back in July and they've remained in contact since then, I would ask you to consider a, maybe a personal bond or 5,000, 10%, something along those lines.
All right. Mr. Parker, go ahead, sir. You had your hand up.
Sir, we don't have any sexual contact. We don't deal with each other other than my son. Like, and my sister had my son now. Like, she came to my job yesterday, and I supposed to take her back to work to keep her. She go to work at 8. I go to work at 6. I supposed to get off work, want to pick my son up, pick her up from work. She take us back home. But like a lot of BS has been happening on. Like, her brother just hit me in the head with a pistol November 29th.
Mr. Parker, let's keep it focused on this situation.
Hold on. Give me just a minute. Awesome. Thank you. All right. Mr. Parker, anything else about your situation you want me to consider before I hit bond?
I'm just frustrated because this is my first time hearing about this. The state, I called the police. The state troopers pulled up and they said that the warrant got active December 14th, and it's my first time hearing about this strangulation. That's not true. We got into altercation. That's not true.
Don't say anything about the incident.
No, okay. I just left. I left. It's my first time ever hearing about this.
Okay. I got it.
I got my own house. I'm working 6 days a week. We don't spend a night with each other. None of that, man. She got her own house. I have my own house. Like I said, this is my first time ever hearing about this.
Well, but the problem is this. You got another 14 years. You got to deal with this lady until that child's 18.
All right,
and I'm not asking you any questions right now. I'm just giving you some advice, brother. You got to figure out a better way to take care of your business with her because it ain't going away, so that you don't keep getting arrested.
Exactly. That's the same thing my mother told me.
Well, listen to your mother. You're almost always well served if you listen to your mother.
I'm her only son, oldest at that.
All right. Okay. Anything else before I set bond, Mr. Bitar?
No, thank you, Your Honor.
Your Honor, if I could help you.
Absolutely.
The obvious is no contact. We wouldn't be opposed to a personal bond.
with the attachment of a tether, if that would be reasonable to you.
You know, here's my concern, and maybe you can shed some light on this. I was told last Wednesday on my felony docket by one of the attorneys that right now, if I order a GPS tether on somebody, they're probably in custody for a week before they can get the tether set up.
Really? Okay. I'm not aware of that. I just know
Dan,
I don't know how long it lasts or how long it takes. So
yeah, Dan, do you have any input on that?
That's pretty much accurate, Judge.
Yeah.
I didn't catch that. Can y'all repeat that? I'm sorry, I didn't catch. I didn't understand.
Yeah. The officer that's with you is suggesting maybe a GPS tether as part of your bond. And I'll be honest with you, brother, I don't want to do that to you because that means you're going to miss Christmas. You'll be in jail for at least a week, probably longer because of the holidays.
Yeah.
So I'm inclined to give you a personal bond, guy, but don't make me sorry I did this.
I'm not sure. I promise you. I have 2 kids. I work 6 days a week. I'm supposed to be at work right now. I was at work yesterday when it happened.
And your sister, right? But the son or daughter with Miss Roberts?
No, we have a son. My daughter, she probably with my sister too. Okay. Like I don't even deal with his brother.
So has your son been staying with your sister long term, or just because this came up?
My son, like, basically stay with me. I'm fighting like full custody of my son. Like we went through a CPS little case. Like she's not stable at all. That's probably why I keep on going through this. Like
so you're involved with the front of the court
right now, man. I swear to God, like I don't go through this at all.
You're involved with the front of the court?
Front of the court, yes, sir. I'm on child support for my son.
All right. All right, I'm going to order no contact. That means don't send her a Hallmark card for Christmas. No text, no tweets, no social media contact. I don't want you to have any direct contact with her whatsoever.
Okay, no problem. So I promise you.
If she calls you and begs you, you got to get together and have coffee and talk about your son. No, she can't change this order. Just me or another judge in this building with a black robe.
Okay, sir.
So have nothing to do with her directly.
That's how it is now, sir. It is.
Well, obviously not, or you wouldn't be standing where you're standing right now.
Mr. Parker.
Yesterday.
Mr. Parker, you're winning. You're winning. You don't need to say anything else.
Yeah. Emotional, man. I don't go through that. I'm so sorry, man.
All right. So no contact. If your sister wants to talk to her about your son, that's fine, but only about your son, not about the legal problems.
Yes, sir.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $10,000 if you violate bond? Condition 1, you cooperate with your next attorney so we can have a meaningful court date on December 30th. Condition 2, no contact with the lady.
Yes, sir.
Put your hand down. We're going to do that on the 30th, and for notice purposes, 9:30 in the morning.
Judge, could you verify that his correct phone number is on that court-appointed attorney sheet?
Yeah, I will. All right, so Mr. Parker, you know you're going to hear from another attorney. It will not be Mr. Bitar that represents you on that next court date.
Correct, he told me that.
All right, good luck, sir. Oh, I'm sorry, Damien. Case number is 20-1684.
I'm sorry.
1684. 1684.
Got it.
All right, thank you. All right, Mr. Coleman, we're back.
Yes, sir.
Mr. Coleman, so we've got two main problems as I see it. Number one, we've got this probation violation, and number two, we've got a lot of money that you owe us. Working 10 hours a week, I don't see where you're going to be doing much to pay this $2,500 anytime soon.
Well, I can get another job. Like, so when I get out today or tomorrow, I can get out and I can get another job. Like, that's no problem, sir. Like, I just don't want to miss Christmas or nothing. I just want to keep focused on my.
No, I'm with you. I'm with you. The recommendation from probation on the probation file is that you do some time on a house lockdown with a GPS tether, and then we'll close your file and just put you on a collection plan for the money you owe us.
Yes, sir.
Here's what I'm thinking right now, and I'm going to give Mr. Bitar a chance to talk me out of it or try to. I'm going to order that you do 30 days on the tether. I'm going to have you report for that tether Monday so you don't miss Christmas. You do 30 days on that tether successfully, and I'll close out your files. I'll give you time for your house arrest to close out your money files. The only thing you're gonna have to do is pay your clearance fees when you want to get your license straight.
Yes, sir. Yes, sir.
That's a Christmas present.
Yes. And that's like today, like for a personal bond, I get out.
I'm gonna give you a personal bond. One of the conditions is that Monday morning you show up. It probably Damien will probably have to have him report to you.
Yes, sir. I will
Yeah.
not.
Talking the 28th, Your Honor?
Yeah, so Monday morning, the 28th, Mr. Coleman, you'll have to report to the Romulus PD before 9 a.m. Is that a good time, Damien?
8 a.m. would be better.
8
8 a.m. All right.
Be there at 7.
No.
And
Okay.
that's when you're going to get your tether set up. Your tether is going to be set up. So you got it for the next 30 days. You got to be at home and only at home.
Yes, sir. Yes,
You're not going out for New Year's Eve. You're not going out to get milk for grandma. You're at home. You're on house arrest.
Yes, sir.
All right. And in essence, Mr. Coleman, I want to drive this point home for you. In essence, I'm paying you $2,500 to stay home for 30 days.
Yes, sir. Thank you.
You understand what I'm telling you?
I appreciate it. I appreciate it, sir.
That's a big gift, Mr. Coleman.
It is.
So
I really appreciate it.
understanding how generous I'm being, what do you think I'm going to do if you violate that house arrest?
You gonna throw the book at me.
I'm going to throw all the books at you.
Basically, I understand. I appreciate
All right.
it. I really do.
All right, Mr. Bitar, anything else on this one?
Judge, the only thing I'm concerned about are those outstanding warrants. So I think those are going to have to be dealt with. And
yeah, where was that? 27th? The Detroit probably isn't going to be a problem.
no, Woodhaven and Wyandotte, 33rd and 27th.
Oh, yeah, they might pick him up.
No, it's just like driving off suspended license. So I really doubt it. So it's not like it's not like anything major.
You understand that I'm going to put you on a personal bond on these files. If those other courts want you, you got to deal with them.
Yes, sir. Yes, sir.
So I can't promise you're home for Christmas because it's not up to me now.
Yes, sir. I understand.
All right. Raise your
And
right
if,
hand. Go ahead, Dan. I'm sorry.
I was just going to say if Lieutenant Hall can just make note of that if he doesn't show up Monday to get his tether, it could be because he's in custody on one of those other cases.
Right.
Yeah, we'll know. I mean, if they when we contact him today, if he starts bouncing around, I'll just assume he's still in custody.
Thank you, Damien. All right, Mr. Coleman, raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 on each one of these 4 files for a total of $4,000 if you don't do what I tell you to do?
Yes, sir.
All right, so between now and Monday, you're laying low, stay out of trouble.
Yes, sir.
Monday, you're going to report to the Romulus PD before 8 a.m. so you can get that tether set up.
Yes, sir.
All right. Merry Christmas.
Thank you. Happy holidays.
Thank you, Judge.
You're welcome. Merry Christmas to you too, Dan.
We got one more, don't we, Your Honor?
Yeah, you and I do, but Dan doesn't.
Yeah, I'm done. They didn't want to talk to me.
All right, Dan. Take
Mr.
care.
Herdman must,
Merry
Mr. Herdman
Christmas,
must know
Lieutenant.
Dan, doesn't want to talk to him. Take care, Dan. You are Rochelle Herdman?
Yes, sir.
Good morning, ma'am.
Morning.
I've got a file here from December 20, 2020. The charge is domestic violence. That is a misdemeanor. It carries a possible penalty up to 93 days in jail, up to $500 fines plus court costs. Do you understand that, ma'am?
Yes.
All right. Generally speaking, do you understand your rights?
Yes.
You've decided to go forward today without the benefit of an attorney. Is that correct?
Yes, I did.
Okay. All right. Understanding your rights and understanding the possible penalty for the charge, how do you want to plead?
I'd like to plead not guilty to this charge.
Okay. Is your address on Osgood a good address?
Depending on the outcome of all this, it may have to be changed.
All right. Mr. Kulo lived there as well?
Yes.
All right. Lieutenant, yeah, I see it. Never mind. Do you have another address that would be good for mailing address if you're not at the Osgood Street address?
Yes, sir.
Go ahead.
8333 Elizabeth 33 Elizabeth Lake Road, and that's in White Lake, zip code 48386.
Zip code one more time, please.
48386.
And that's White Lake, Michigan.
Yes, sir.
Where's White Lake at?
Right next to Waterford.
Okay. All right, how about a phone number? You got a
248.
phone number?
Yes, sir. 248-892-3873.
Thank you. Any prior arrest or conviction history?
I was convicted of theft when I was like 18. I was convicted of a marijuana charge in Tennessee in like 2013. I've been arrested twice now with Mr. Kulo for the same thing, but was never charged. The charges
Okay.
were dropped.
Have you come to any conclusions about your relationship with Mr. Kulo?
Yes, I need to get out of there.
All right. So I'm going to set up a court date for you, a pretrial, January 28th at 9:20 in the morning.
Okay.
The nice officer is going to give you a written notice. Hang on to it. Our case number for Ms. Herdman is 20-1705. Ma'am, is there any reason why you have to have any continued contact with Mr. Kulo?
I need to get my stuff from the house. My car's there. Everything I own is there.
Okay.
And that's about it. If I can get my crap out of there, I can be gone out of
All
his
right. I'm going to order that you have no contact with him or that address other than if you set it up with the Romulus PD for a civil standby. With a civil standby, you can go pick up your personal property. The police can be there to make sure there's no further problems.
Okay.
Understand, the police are not going to mediate if there's a dispute between you and Mr. Kulo about who owns what.
Right.
All right. So, your clothing, the car that's in your name, that kind of stuff is not going to be an issue. But the big screen TV that he says is his and you say is yours, that's going to stay there until there's some kind of court judgment.
Okay.
All right. I'm going to put you on a personal bond with two conditions. The first one, that you not go back to that address without, actually three conditions. First one, that you don't go back to that address without the PD with you. Second condition is that you have no contact with him. No phone calls, no letters, no Christmas cards. You see him at Burger King, you're eating Taco Bell. No social media contacts, so you're not tweeting, texting, email, and none of that stuff. Don't have your friends call him. He tracks you down wherever you're at and begs you to meet for Christmas coffee. He can't change the order, only myself or another judge in the building.
Okay.
So in essence, you forget he exists.
Right.
All
Understood.
right. And then the last one is you cooperate. So on January 28th, we can have a meaningful court date. That'll be by Zoom, the same way we're interacting right now.
Okay.
If at that point you want to have an attorney represent you, that's the date you'll want the attorney, and you will still have the option to request the advice of a court-appointed attorney on the 28th of January if you choose. Do you
Okay.
understand all that, everything we've done?
Yes.
Raise your right hand for me, please. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you violate bond?
I swear.
Any questions, ma'am?
No.
Good luck to you.
Thank you.
You're welcome. Merry Christmas.
Merry Christmas.
Thanks, Your Honor.
Damon, stay well.
Good afternoon, Cynthia.
Hello.
You're the first one to check in. I'm going to put you back in the waiting room. We don't have an attorney yet, but I do have you marked as the first one. Okay?
Okay. All right.
So
Thank you.
just hang in there.
Okay.
Good afternoon, Mr. Yaldo. I'm going to let Judge know that you're in the meeting room now. We do have one defendant who's checked in, and that is Cynthia Shepherd. But let me get a hold of the judge real quick, okay?
All right, thank you.
I'm going to mute you for right now.
That's fine.
I'm sorry, Mr. Yaldo, were you speaking with us?
I'm sorry, I'm just talking to one of my clients real quick.
Okay,
I'll
okay.
be right there.
Thank you.
Yep.
Fortune 3, what's the name that you're appearing on?
Tara Schultz.
Okay, I'm going to stick you back in the waiting room for just a few. Is Mr. Schultz joining? Do you know?
No, he's not.
Okay, thank you. We'll call you back in just a few, okay?
Okay.
Mr. Yaldo, are you there?
Yes, Your Honor.
Good afternoon, counsel. Your appearance on Swan Creek versus Shepherd. Good afternoon, Ms. Shepherd.
Hello. Your Honor, for the record, Jeremy Yaldo, P82238 on behalf of Swan Creek.
Thank you. Okay, Ms. Shepherd, how about an update from last week?
Well, we're a little farther along. They requested the rent receipt, basically the ledger for the last 6 months, and I received that this morning. And I sent it to them this morning before court. So that's as far as I've gotten. Do you think we could just, so we don't have to keep coming back, just rule, let me pay January's rent on time here and then start the 200 a week? And then if the state pays some, then yay for me. If not, we're just good.
At this point, Mr. Yaldo, I'm assuming you want to get a judgment on the record.
That is correct, Your Honor. I would like to seek a judgment just for the normal 10 days. But I guess based on the 10th day falling on a weekend, I would ask it to be for January 4th as the writ date.
Okay, so what's the number we're looking at, counsel?
$4,573.62, and that includes court costs of $158.
So that's all inclusive.
Yes.
All right. So Ms. Shepherd, if you're fairly confident that you've got the agency on board, then we could enter a consent judgment that says you agree that you owe the $45.73 and change.
Okay.
You've got until January 4 to get that paid.
Yeah, January 4th. I'm sorry.
Right? Yep. January 4 to get that paid. Or at that point, Swan Creek can bring in and file a writ of restitution, which is actually the eviction paperwork that once it's filed, the court officer goes out and posts on a door. That gives you the 24-hour notice that they're going to come back and move you out.
So I can't do the payment of the rent and then the $200 a week until it's paid, because I don't want to say that they're going to pay it and then they don't, and then I'm in trouble.
I mean, Your Honor, I'm going to object to the payment just because, I mean, we don't know what she's getting approved for. You know,
Well, this is saying if I don't get approved for anything, I'll pay it all myself. I'll pay January's rent on time, $200 a week until everything's paid up. February's rent will be paid on time, plus the 200, you know.
Your Honor, do you mind if I just talk to my client real quick?
No, not at all. Not at all. You want to just mute and call him?
Yeah, give me one second.
Yeah, that's fine. That's fine. Go ahead.
While he's doing that, I'm going to find out who this other
Yep.
person is.
The OnePlus.
Yep.
Hang with us, Ms. Shepherd.
Okay.
Good afternoon, sir. Can you tell me what your name is, please?
Reginald McLemore Jr.
I'm sorry?
Is Reginald McLemore Jr.
Okay. Okay. We've got your name now, and I'm going to stick you back in the waiting room. You're coming up in a few minutes, okay?
Okay.
Thank you, sir. Okay, it's Tara Schultz next, Judge,
Yep.
and then Darlene Hall.
Yep.
Thank you.
Your Honor?
Yes, sir.
Okay, so I had just talked to my client. We still want to seek the judgment. Now, my client has offered Ms. Shepherd a deferral program, which is an in-house program by the community to potentially put a down payment. And if she's approved, she can basically put her past due balance over a certain time period to pay that off.
Explain that because it confused me.
Okay, sorry. So basically, she would put a down payment towards whatever balance she owes. So say she were to put, $573.62. Then that $4,000 would basically be put over, a time period to get that paid off. So it's almost like a repayment period to where you could potentially get approved for paying it like
Okay.
$200 a week or
Okay.
$100 a month.
So basically exactly what she's asking for, except for they want a lump sum to get it started.
Correct.
Okay. And what would her time frame be to pay that 573 within that 10 days?
Well, I mean, it's actually based on the amount that she's able to come up with as the initial
Okay.
payment. So it's not necessarily the 573.
Okay. So the question is for Ms. Shepherd, how much money can she come up with between now and January 4?
Okay, got it.
That is,
Right.
and then she would just relay that information to my client. And then my
Okay.
client would basically submit the application to see if she gets approved for the deferral program. And then they can discuss, potential repayment plans or options.
Yeah, the payment amounts going forward.
Correct. So,
Okay.
but at the time I will still ask for a judgment. And if they can work out some other agreement, then that's fine.
Okay. Ms. Shepherd, are you comfortable with that?
As long as the agreement is, I'm not agreeing to the judgment, and then they're just not going to agree to the
Right. Well,
five.
here's your protection on that.
Uh-huh.
Okay. Let's just assume January 4 comes and go, and on the 5th, and I doubt if it'll happen that quick, but on the 5th, you come home from work and you got a notice on your door that says the court officers have been out there. You can contact the court and say, wait a minute, I want a hearing on this because I've been trying to communicate with them about a payment plan and they just won't talk to me.
Okay.
All right. So I'm still the gatekeeper to whether or not you get evicted.
Okay.
You've got the right to request a hearing. So then we're going to be doing this. And I'm going to say, Mr. Yaldo, the lady says that your people won't even talk to her.
Okay.
Right. And at that point, Mr. Yaldo knows I'm not going to let him evict you.
Okay.
Because we've got an agreement that everybody's going to act in good faith to try to work something out. If you've offered some money and they won't even say yes or no, that's not good faith.
Okay.
Now, if you offer them $200 to start and you want 16 years to pay the balance,
right. Yeah.
and they turn that down, I'm probably going to decide that's a reasonable turn down.
I would too.
You hear what I'm saying?
Yeah, absolutely.
Okay. I'm not giving you any guarantee that
Right.
they're going to be reasonable. All I'm telling you is I'll listen to that. And if I think they're unreasonable, then I'm not going to give them their eviction and we're going to be back to the drawing board.
Okay. All right. Sounds good to me then. I
Hold on though. Just to be fair, I got to warn you.
Yes.
Your idea of what's reasonable and my idea of what's reasonable might be different.
Yes.
Okay. All right.
Yes.
Mr. Yaldo, are satisfied going forward with those terms?
Yes, Your Honor.
All right. So what we're going to do, Ms. Shepherd, is you're going to give Mr. Yaldo an email address if you've got one.
Yes.
He's going to draft a consent judgment. He's going to email it to you. And I think he's been pretty prompt. He'll probably do it today.
Okay.
He's going to email it to you. You're going to look at it. And if you're satisfied, it's pretty clear cut at this point. It's $4,573 and change by the 4th.
Right. Yes.
You're going to send back an email to him that says it's okay to sign your name.
Okay.
He'll sign your name with permission. He'll sign his name on behalf of Swan Creek. He'll submit that to the court for me to sign it and make it a legally binding judgment.
Can I ask for it to be on the 7th? Because on the 6th, I'll get paid again and I'll be able to increase the amount I can put down.
That's fine. Your Honor.
Okay.
Okay. Thank you. Thank you. Merry
I'm-
Christmas.
That's
Mr.
like
Shepherd.
another 500 for you.
No.
Ms. Shepherd, as long as you once we get off the phone or get off the Zoom hearing,
Yeah.
please contact my client to start that deferral program that they've been trying to get you to participate in.
Okay, I absolutely will. She did tell me about it, but that's as far as I got with her. But thank you so much.
All right. So we need an email address from you, ma'am.
Oh, for me, it's Cindy, CINDY, Combs, COMB as in boy, S, Shepherd, SHEPHERD @gmail.com. So Cynthia Combs Shepherd.
Okay, perfect.
Okay.
All right. Do you want an
Ms. Shepherd-
updated phone number? I'm sorry.
Go ahead. Yeah.
Just in case I need to get a hold of you.
Okay. 734
Okay.
559 3480.
I'm changing it in the court file too, Ms. Shepherd. 559
3480.
3480.
Yes.
Okay. Good luck, ma'am, and Merry Christmas.
All right. Thank you. You as well. And you too, sir. Thank you for being understanding.
No
You're
problem.
welcome.
Thank you.
Right,
Mr.
bye-bye.
Yaldo, we're going to
Yes,
say
ma'am.
goodbye to Ms. Shepherd, and we're going to bring Tara Schultz in.
Okay.
And she advised Mr. Schultz will not be joining.
Thank you. Good morning, Ms. Schultz.
Good morning.
Counsel, your appearance for Swan Creek.
Your Honor, for the record, Jeremy Aldo, PA 2238 on behalf of Swan Creek.
All right. And Ms. Schultz, what's your update with your diversion program? Any update?
Yes, I paid the $3,500 in a cashier's check last week, and I also made my first payment of the in-house payment plan on Thursday. And then yesterday I made my January rent.
That's a lot.
Yes.
Yeah, it is. Your Honor, just to let you know, so I guess last time we were in court, Ms. Schultz had stated that she was doing participating in an in-house payment, and that was something that I needed to verify. So my client had confirmed that there is an in-house payment agreement going on. And it looks like, Ms. Schultz, I have in front of me, if you can just confirm, it looks like $390.28 to be paid by 12/8, 1/8, 122, and 129. Is that correct?
Yes, that's correct.
Okay. And that should basically get you caught up to where starting February, you are starting fresh, basically.
Right.
Okay. So, Your Honor, I mean, at this time, I would probably do a conditional dismissal.
Okay.
Regarding those conditions. And if she defaults on any of those payments, then I would just, ask the court for a judgment and a writ.
All right. Ms. Schultz, any questions?
No, I don't have any.
Good luck to you, ma'am.
Okay, thank you.
Ms. Schultz, do you mind if I get an email address? And just let you know we're on live YouTube. So if you're comfortable with doing that, you can go ahead.
I'm sorry, what was that?
Are you comfortable giving us your email address?
Oh, yeah, that's fine.
You're out on the World Wide Web with YouTube though, just so you know.
Oh. Is there another way I can give my email
I
address?
can give you my phone number and you can call me. Does that work?
Yes.
Okay.
Okay, what was the phone number?
248
Mm-hmm.
971
Okay.
1430.
Okay.
If you want, you can even shoot me a text message on that and just tell me what your email is. And then I'll draft a conditional dismissal, send it over to you for your approval. And then we'll get it entered into the court, okay?
Okay, sounds great.
All right, thank
All right,
you.
Ms. Schultz, you're just going to read that. If you agree with it, tell Mr. Yallo he can sign your name.
Okay, yes.
Then he'll sign both his name and yours and send it to the court. We'll get it moving.
Okay.
All right. Merry Christmas, ma'am.
All right, Merry Christmas.
Merry Christmas.
All right. Good afternoon, Ms. Hall. Mr. Yaldo, your appearance for Rawsonville Woods.
Your Honor, for the record, Jeremy Aldo, PA 2238 on behalf of Rawsonville Woods.
All right, Ms. Hall, do you have any update from last week's meeting?
Well, I got turned down from the state of Michigan for help, and Metro has no more funds at this moment. But MISTA has gotten all the COVID funds. So I put my application in at MISTA, and they said it would probably be the first week in January.
Wow.
But they can help me. I meet their guidelines and all this other stuff. So, which I'm happy about. But that's where I'm at.
Okay. All right. And how much is owed on this account, Mr. Yaldo?
Your Honor, the amount owed is $2,710.44, and that includes court costs of $166.
Okay.
So, Your Honor, I would ask just for a judgment for a writ date of January 4th, 2020 or 2021.
All right.
Okay.
Ms. Hall, are you willing to enter into a consent judgment for that amount with Mr. Yaldo?
Yes. Yeah. That's for sure what I owe.
Okay.
I just, and with MISTA, I had to give them the total amount that I owed, which by January the 1st, I will owe more.
Right.
So I'll have to add on that to them.
Well, hopefully, if you provide them with a judgment that shows that you've got a date certain where you've got to have some money, they might be able to put you in, move you up the front of the line.
Right.
Yeah.
Right.
All right, so what was our move out date on that one, Mr. Yaldo?
January 4th.
All right, so it's January 4 is your crunch time.
Okay.
On January 4, if Rawsonville doesn't decide to give you more time on their own, then on January 4, that's the deadline where they can now come to the court and file the next piece of paper, which is actually the eviction notice.
Okay.
Understood?
Understood. I wrote it down.
Okay, and Mr. Yaldo is going to want an email address for you because he's going to prepare this document, this consent judgment, send it to you for your approval. If you're okay with it, let him know with a return email. He'll sign your name with permission, sign his name, and submit it to the court for my signature.
Okay.
And we're zooming on YouTube right now, live stream. Are you okay with giving him your email on live stream, or do you want to call him and provide it?
Oh, no, that's, it's Darlene Hall 48 at gmail.com.
Thank you.
Yeah, it's an easy one.
Ms. Hall, good luck and Merry Christmas.
Merry Christmas to you too. You guys be safe, okay?
Thank you.
I'm going to bring in Mr. McLemore.
Thank you. Good afternoon, sir.
Good afternoon.
Counsel, your appearance, please.
Your Honor, for the record, Jeremy Yaldo, PA 2238 on behalf of Country Meadows.
Mr. McLemore, we met last week, and at that point, you were working on some kind of a diversion program, I believe. Is there any update?
Yes, from what I was told that Wayne Metro was in contact with the front office.
Your Honor, I did have a chance to speak with my client. Wayne Metro has contacted my client regarding the landlord's application part of it. My client has submitted it. We're just waiting to hear back from Wayne Metro. So at this time, we would ask that we just adjourn this matter so we can further get this resolved and hopefully reduce this to a conditional dismissal.
Okay, let me get my hands on a calendar. I forgot to bring one up.
All right, thank you.
Thank you. Counsel, what are you thinking?
Do you have any availability the first week of January?
Yeah, I've got lots of afternoon time.
Could we do the 5th?
Tuesday?
Yes.
Yeah. Mr. McLemore, mornings or afternoons matter to you?
No.
Okay. You want to just do 1:30 on the 5th, counsel?
Yes, that works, Your Honor.
Mr. McLemore?
Yes, that's great.
Okay.
And Your Honor, if I may ask, Mr. McLemore, if for some reason we do get information received from the agency, is there a phone number or an email that you can send me where I can contact you? Maybe we could try to get this resolved to a conditional dismissal before the next hearing date, so then you don't have to appear for the next hearing date.
Yes, you can have my number and email.
And just so you know, we're on live YouTube. So if you're comfortable with giving out that information, great, go ahead. If not, I can give you my phone number and you can shoot me a text message with that information, whatever you prefer.
I'll take your phone number.
Okay, just let me know when you're ready.
Okay.
248-971 1430.
Okay.
Okay, so just shoot me over your information, and then if we do get information back from the agency, then I'll contact you and we'll try to get this resolved before the next hearing date. Okay.
Okay.
Sounds good. Thank you.
Mr. McLemore, good luck and Merry Christmas, sir.
Oh yeah, Merry Christmas to you.
Thank you. All right, bringing in Jayla Williams, Mr. Yaldo.
Okay.
Good afternoon, Ms. Williams.
Good afternoon.
Counsel, your appearance for Providence Harbor Club.
Your Honor, for the record, Jeremy Aldo, P82238 on behalf of Providence Harbor Club.
All right, Ms. Williams, we spoke last week. Is there any update on your diversion program attempts?
Yes, she actually sent all the stuff to Harbor Club. Harbor Club just has to fill out the paperwork and send it back.
Your Honor, I can confirm that I did speak with my client today. They did receive it yesterday, the paperwork. They are in the process of filling it out. So I would ask for an adjournment for the same date and time as the previous case.
Sure. Ms. Williams, are you available Tuesday, January 5 at 1:30?
Yes, I am.
All right, we'll see you then. Hopefully we can wrap this thing up.
All right.
Any questions?
Thank you so much. Nope.
Good luck and Merry Christmas.
Merry Christmas to you as well.
Thank you.
Thank you. Bye-bye.
Counsel, you got any news on Weinman, Lauren Weinman?
No, all I can tell you is that she has dropped her balance down significantly. And I think she's going to be paying off the remaining balance by the end of this week. So
Let me try to call her real quick, if that's all right with you.
That's fine.
Ms. Weinman, please.
Yes, this is her.
34th District Court calling. Are you available for your Zoom meeting that was scheduled at 1:30?
I thought I didn't have to go to that because everything was paid. They told me I didn't have to show.
Okay, management told you you didn't have to show?
Yeah, because they had gotten the check. They called and said they got the check. So I assumed that they spoke to their lawyer.
Okay. Have you made a payment or are you paid up? Which one?
I made the payments, yes.
Okay. Counsel, what do you want to do with this one? You want to adjourn it to January 5 to wrap up the paperwork?
No, Your Honor. I think this one I would just ask for a judgment. I mean, there's $475 and some change left on this.
Okay.
So that's what I would ask for.
All right, Ms. Wyman, you okay with a condition or a consent judgment for the $475 amount owed? Pay it or pay it by January 4?
It'll be paid by tomorrow morning.
Okay.
I
So
already let the office know.
you want to just see if it gets paid tomorrow and just dismiss it, Mr. Yaldo?
Sure. I mean,
She
if
thinks she's going to pay it tomorrow.
Okay, if
It's
not,
like
then
gonna be in the Dropbox tonight. They just won't be able to, process it till
Sure,
tomorrow.
sure. She said she's going to drop $475 check in the Dropbox tonight.
okay. So, Your Honor, would it be okay if I'll wait on submitting
Sure.
the judgment? and
Sure,
then-
let's do it. Yeah, let's do it that way. All right. So Ms. Wyman, if it's all right with you, Mr. Yaldo is going to submit a consent judgment to the court. Actually, yeah, let's do it as a consent. He's going to send you a consent judgment if they don't get that check processed tomorrow.
Okay.
Just so we can wrap this case up one way or the other, either with a dismissal because you paid the check or a judgment that gives you 10 days to pay the check. So Mr. Yaldo doesn't have to keep coming into Zoom and either do you.
Okay, I'm sorry. I thought this was already done for the I didn't get on the.
That's all right. Breakdown of communication. No problem. That agreeable to you, ma'am?
Yeah, that's fine.
Okay. Merry Christmas.
Your Honor.
Hold on, ma'am. Yes, Mr. Yaldo.
An email from her so I can get just her permission just in case.
Oh, yeah, yeah. Ma'am, let me mute on my end. I'll get it privately and we'll call you with it.
All right, thank you.
I will wish you a Merry Christmas.
All right, Merry Christmas to you and yours.
Thank you. All right, counsel.
Yes.
Yeah, hang out for a minute. I'm gonna, let's see if it's been a while since I've chatted. Let me see if I can just send you this email by chat.
Got it.
Paula does those usually. See if that worked.
Yep.
All right, we got it?
Yes.
Okay.
Perfect.
So I'll wish you a Merry Christmas
Thanks, you too.
and we'll see you next year.
All right, you got it.
All right, be well.
All right, you too.
Okay, we still got to leave it up for that motion. All right.
But,
Your Honor.
Good afternoon.
Good afternoon, Judge.
Mr. Knappman's joining.
Yeah.
All right, I think we've got everybody. Gentlemen, your appearances one more time for McGahee versus Zabek.
Your Honor, my name is Guy Vining. I represent the defendant.
And good morning, or afternoon, Your Honor. John Knappman on behalf of the plaintiffs. And Mr. Zabek is here as requested. He's sitting here in my conference room with me.
Good afternoon, Mr. Zabek. Thank you for joining us.
And by the way, that's in spite of the defendant going over and trying to talk him out of it or trying to tell him to say that she can stay. Since the last time we were in court this morning.
All right, thank you. Mr. Zabek, can you hear me all right, sir?
Can you hear him? Go on.
Mr. Zabek, can you hear me?
Can you hear him? Try again, Judge. I turned up the volume.
Thank you. Mr. Zabek, can you hear me?
He's asking, can you hear him? Can you hear the judge?
No.
Try again.
Mr. Zabek, can you hear me?
Yeah, now.
Okay. Good afternoon, sir.
Good afternoon.
Mr. Zabek, would you mind raising your right hand for me? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today, sir?
Yes, I do.
Thank you. Mr. Knappman, it'll probably be easier on me and Mr. Knapp. You can put your hand down, sir. Mr. Knappman, it'll probably be easier on all concerned if you just did a little voir dire, so I'm not shouting at Mr. Zabek.
Okay. Mr. Zabek, you're the owner of, let me get my file out.
Excuse me.
Okay. Mr. Zabek, you're the owner of the property at 28890 Prescott in Huron Township?
Yes.
And that's the barn next to the house?
No, that's actually a house, right?
That's the house.
There's a house, not house.
28890.
House.
Okay.
She's actually.
Okay, Mr. Knappman, who else is in the room with you and Mr. Zabek?
Also in the room is his daughter and her husband.
All right, why don't we ask them to step out so we can have some kind of a semblance of a fair process here?
Okay.
They're not allowed to listen.
I guess not. Okay. The 28890 Prescott, is that your
Right,
house?
Right,
And you also own the barn?
yes,
And that's where Tracy lives?
yes.
And sir, there's been a question as to whether you want to evict her or not.
Yeah, I and my wife decided to get her out of there for reasons of theft and,
You want to get her out.
right,
So you support the efforts by your daughter to file for an eviction.
correct. Because I'm getting too old to handle everything verbally, and, I gotta have somebody in the family that's with me, you know what I mean?
Okay. I think that should be sufficient, Judge, unless you have questions.
Mr. Vining, any questions for Mr. Zabek Sr.?
Your Honor, I have a few questions.
Let's see if Mr. Zeta can hear you.
Can you hear me okay, Mr. Zabik?
What'd you say?
If not, I'll repeat everything. How's that? And
That's
then,
fair. That's fair enough. Mr. Zabik, at the front of your house, is there a mailbox?
at the front of your house, is there a mailbox?
Yeah, at the front of my house, yeah.
Yes.
Are there two mailboxes for the property at the front of your house?
No.
Are
I
there
don't-
two mailboxes?
No, I don't know. No. I don't know.
No.
Is there a mailbox at the barn in the back of your house where Tracy lives?
Is there a mailbox at the barn where Tracy lives?
Well, I usually everything was addressed to me. You understand what I mean? She just started getting mail since this turmoil. You understand what I mean?
Okay.
But now when the turmoil, she's working with lawyers and everything. She's getting mail personally.
Let me ask you this. When, in the past, when your son was alive, when mail came for your son or for Tracy, whose mailbox did it go in?
When mail came for your son, when he was alive, and Tracy, where did the mailbox? Which mailbox?
Same way.
The same box?
Yeah, because I got it next. This is all on one property. The barn's on the same property. You understand what I mean? 289 and 100. But there's a different address for that after I started having somebody there. And
When mail came for Tracy or for your son, before all the turmoil started,
well, I think they had something separate other than even coming there. They picked it up at the last when this turmoil started.
let me ask this. Did you ever see a postman drive through the driveway to the barn to deliver mail?
Oh, yeah.
To the
Yeah,
barn
they
house?
used it. They used it.
Okay, did a postman ever take mail straight to the barn?
No.
Okay.
When mail came from them, isn't it true that you would call them up and tell them they had mail, and then
Right.
they would come to the house to pick up the mail?
Right. Well, if it was in my son's name.
Now, your son died about 2 years ago, is that right?
What did he say?
Your son died about 2 years ago?
Yeah, I think, yeah. I hate to.
Well, I'm very sorry to hear that. And then you say that since your son died, there's been some turmoil, is that right?
Correct. There was turmoil there prior to, but we didn't want to hurt my son because he was a heavy diabetic.
Okay.
And we didn't want to get him riled to the stage that he die on account of something of this nature.
Your son moved, and Tracy moved there about two years ago. I'm sorry, in 2017, because your son became very ill. Isn't that so?
Yeah, they helped in the field. It was a short term for picking crops, and it was vegetable farm.
Okay.
And it was they helped to my son helped drive the tractor and everything because I couldn't do everything. You know what I mean? But that was gone. I don't know how many years since he was died. You know what I mean?
Right.
Since he died, I've been renting it to somebody else.
The farmland.
I don't know how many years he's been dead right now. My daughter would know.
It has been suggested this morning that you are afraid of Tracy Zabik. Are you afraid of Tracy Zabik?
Are you afraid of Tracy Zabik?
Like committing murder or something?
Well, doing harm to either you or your wife.
Well, I don't know if there was any direct thing of nature of hurting us, to us, but she said stuff to other people that came back to us.
So you have some amount of fear.
Oh, yeah, I especially since my son died, I wouldn't trust her. She's got too many. She wasn't fair all the while she was married to my son. But now, and I didn't want to hurt his feelings, so I let it slide. But now that he's gone, I gotta get her out of there.
Right. Mr. Zabik, isn't it true that about every 2 weeks or so, up until this lawsuit started, Tracy would be a visitor in your home to talk to you and your wife?
Objection is to relevance.
Yeah, let's keep it to the eviction process if we could.
Well, sometimes.
No, that's okay. You don't answer that.
Okay.
I'm just checking some notes, Judge. I'll just be.
No, that's all right. Take your time. We're not in a rush.
He doesn't have a question yet. He's thinking. I think you got him stumped.
Like I told you, of all.
Hold on, just let him ask questions.
Did you, prior to this lawsuit, indicate to Tracy Zabik that she may live in the barn up until you died, that you wanted her to be there?
An object is to relevance. I mean, it doesn't matter what he said before he filed a lawsuit.
What's the relevance, Mr. Viney?
Well, the relevance is whose intention was it to file the lawsuit?
Well, I think the point is.
I don't even think, I'll cut you off, Mr. Navin. I don't even think that's relevant, Mr. Viney. It could have been anybody's idea. But if Mr. Zabik Sr. is telling me today that he wants to proceed with the eviction, that's all I need to know. I mean, unless you want to ask him questions because you don't think he's making his own decisions.
Well, that's what I'm wondering what the motivation is. Mr. Zabik, do you have any evidence that Tracy Zabik has done anything wrong to you?
Objection is to relevance.
It's not relevant, Mr. Viney. As the owner of the property, if Mr. Zabik wants her out, he doesn't have to have a reason. If you want to ask him what his reasons are to see if it's really his decision, I guess I'll allow that. I think that's relevant.
But he's already answered that question, Judge.
He's already.
I don't know that he answered the reason. He made it clear that he wants her out, but I don't know if he really gave us a reason why.
Well, Mr. Zabik, isn't the reason why that you want her out is because your daughter, Sandra, leans in that direction?
Is the reason why you want to evict Tracy is because Sandra is leaning that way?
Well, she's with me, but I'm the one that wants her out of there. I'm 90-some years old, and I got her to help me out with this problem. I can't do it on my own at 92 years old. I got to have somebody in the family behind my back, which she didn't live on a farm, but she lived a couple houses down.
Right.
And as I got older, I can't drive no more. I'm 92. I just quit driving at 90.
Okay. All right.
Let me, and I can't do some things that's got to be done mobile and not all by. And if it's by talking to lawyers or something, that I got to talk to them like you people today, face to face, not by phone.
Okay. Well, Mr. Zabik, has Sandra ever told you that she wants to be in charge of everything, or she won't do things for you like drive you and get groceries and that you better do what she says or she's not going to help you.
I'm going to object to that question.
What's the objection, Mr. Knappman?
Once again, it's not based on anything. He already said he wants to evict her. So
Okay, well, what's the
he
legal
said he
objection?
wants to
So I know how
evict
to.
her for his own.
But I got to make
reasons.
a ruling, Mr. Knappman. Give me a legal objection. It's not relevant. It's hearsay.
not
Give me a legal
relevant.
objection. All right,
It's
Mr.
not
Vining,
relevant.
is that relevant?
It's relevant if we're trying to get to the truth of the motivation as to whose decision it is, then I think it's relevant, Your Honor, because if there's some sort of pressure, then maybe it's really not his will that's being exercised.
Hold on.
I'll allow it, Mr. Knappman.
Okay. So the question is, has Tracy, or I'm sorry,
Sandra
threatened that she wants to run everything, and if you don't go along, that she's gonna not take you and drive you and do things that you need?
She never had a driver license to drive. She
Sandra.
Never. Oh, Sandra?
Yeah. Has Sandra threatened you, and that's why you want to do this?
No, Sandra, my daughter, never threatened me. No. Why would she threaten? She's helping me
No.
out here.
I mean,
Sandra here.
threatened with not helping you in the future.
No.
Okay.
No. I mean, no, she never said that because we got to get this resolved. And I got another daughter, younger daughter, that worked for Ford for 35 years. But she wasn't involved with she knew what was transpiring, you know, because I got 50 pieces of property. And I got over $1 million in Edison stock.
Okay.
I got a few bucks in a kitty. That's why she's pushing for everything she can get.
Who?
Tracy.
Okay.
And she's not involved in that. When my son died, she was out of the picture.
All right. If you need, I can ask the question a different way. I don't know if you got a full question and response the way you were intending, Counsel.
Were you troubled with Tracy living in the barn apartment until it became a concern to your wife and to Sandra?
The concern is, if something happens to her now that my son's gone, we'll get sued or something. In other words, we tried to get her out of there right after he died 2 years ago, and she's still there. So that's why we got an attorney to get her out of there.
What did you do 2 years ago?
She stole money out of the house. She stole money off my crops. And everything was theft behind my son's back. And we didn't tell him about it because he had high sugar since he was 16 years old, and I didn't want to rile him. She's a thief. And she lies like a SOB.
What did you ever call the police department?
Why didn't I?
No, did you ever?
I said, did you ever call the
They
police
knew
department?
about it. They knew about it, but I told them just stand the thing that don't do nothing. But how would I say? I didn't want to do anything while my son was alive. For the third time, I'm telling you.
Isn't it true that Tracy Zabick, is pretty near blind? She can't even see where she's going.
Isn't it true?
That's a lie. She couldn't do what she's doing if she's blind. I don't know what percentage she's blind, but she ain't even wearing glasses.
All right. Well, you don't know whether glasses, the typical glasses that you wear or I wear, would even help her, do you?
All right, we're getting off track. What's her vision got to do with his desire to evict?
Well, he's alleging that she's, a cat burglar, that she's broken into the house, she's stolen things, and so I'm just.
But once again, Mr. Vining, if the owner of the property wants her out, there is no lease that gives her right to be there.
I understand.
His reasonings don't even have to be reasonable to us.
Yep, I know, I understand. I understand what the law is. My main point was, and he disagrees with it, that it wasn't his motivation, but it was his daughter's motivation. So I've concluded my examination, Your Honor. Thank you.
Thank you.
I do have.
Mr. Zabik, I want to thank you for your time, sir.
Well, thank you.
I do
All right,
have.
gentlemen, anything else?
I have a few questions of my own client, Your Honor, if I might just make a brief record.
He wants to.
Go
ask
ahead.
her.
Who's this?
Thank you, Judge.
Ma'am, raise your right hand.
Raise your right hand.
This
Ma'am, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today?
Yeah.
Thank you, ma'am. Go ahead, counsel.
Tracy, you were at one time married to Brad.
Mr. Vining, I apologize, sir. I apologize. Mr. Knappman, I don't have any objection unless Mr. Vining does. If Sandra wants to come back in the room now that Mr. Zabik is done testifying.
Okay.
No, I have no objection. No.
Okay.
Okay, you guys can come back in and do something.
Mr. Vining, go ahead. Once again, sorry for the interruption.
Tracy, were you married to Bradford for upwards of 30 years?
Yeah.
And did Bradford become sick in the year 2017?
He was sick for many years.
Did he become so sick he couldn't work in 2017?
Yeah.
You have to speak.
A little louder, Miss Zabik.
Yes.
I didn't hear what you said.
Don't worry about it. I've got it. You just relax. You're done.
And that's when you moved into the barn apartment, is that right?
Right.
How far from the main house is the barn apartment?
About 100 feet.
And did Bradford pass away the next year, December of 2018?
Yeah.
Between 2018 and up until, say, October of this year, have you been a guest in the home of your mother and father-in-law?
Yeah.
Once again, objection is to relevancy.
What's the relevance, Mr. Vining?
I'll withdraw the question.
Thank you.
On the at the front of the main residence, is there one mailbox or two?
One.
When mail would come for you and your husband, what address would it come to?
28900 Prescott.
And that's where Mr.
Somebody-
William Zabik lives.
Yeah.
What would they do to get the mail to you?
They would call and tell me I had mail.
Is there a mailbox at the back 100 feet away from the main house
No.
on the barn?
No.
There's no mailbox on that?
No.
Does a postman ever drive down the driveway to go to the?
No.
He's bringing it to our house.
Did you receive in the mail or personally delivered to you any document called the notice to terminate your tenancy, telling you you had 30 days to leave?
No.
Did you receive in the mail or by any other means a summons and a lawsuit to terminate your tenancy?
No.
Did you receive a copy of the judgment, which is dated November 24, 2020?
That's the letter I got from
From the court.
the
Can't hear the answer.
Yes.
And how did you receive that?
It was taped to the front door of the barn in a baggie.
These other items were never taped on your house?
No.
Have you, let me restart. Judge, I'll withdraw that.
It's all right.
During your husband's lifetime, did he work in the construction and the farming industries?
Yes.
And as a consequence, did he acquire a lot of construction and farming equipment?
Yes.
Objection. Once again, this is irrelevant and moving beyond the scope of today's hearing. Unless I get to ask
Relevant?
about the stuff she's taken since.
Is it relevant to the eviction process, Mr. Vining?
Only in the sense that I was going to have her testify to the amount of it and the fact that it can't be moved in the next 10 days or so, if Your Honor were to rule against us. So I think it's relevant because.
Well, let's do it this way. Mr. Natman, would you stipulate that there's a lot of property there that ownership is in dispute?
Yes, I think it's in dispute. I think she's already taken about 5 pieces of equipment off the property.
All right.
But
I don't think I need to hear any testimony
doesn't
about
matter
it. Let's
within
move
the
on.
10 days.
And the money.
All right, let's move on, Mr. Vining.
Was the first notice that you ever received of this lawsuit on or about December 1st of this year?
Yes.
Well, Your Honor, under the circumstances, I have no further questions.
All right, Mr. Natman, do you have any questions for Miss Tracy Zabik?
So the judgment, when it was posted on the door, you found that, right?
Yes, in the envelope.
And you contacted Mr. Vining to represent you at that point?
Yes.
So you were able to get notice to something posted on your door?
Correct.
But when the bailiff said he posted the previous thing on your door, you didn't get that?
No,
I haven't, I'm going to object. That's a hearsay. He's assuming facts that are not in evidence. There's been no testimony that I know of the bailiff posting anything.
It is a part of the court record, though. It's part of the court file.
What part is that, Judge?
The proof of service has been filed with the court. Shows that there's been service by attachment. We talked about that earlier this morning.
Of the summons and the complaint, or of the judgment?
The summons and complaint. Mr. Natman, proceed.
I have no further questions.
Okay, Mr. Vining, any redirect for Ms. Zabik?
No, Your Honor.
I have one question. Ms. Zabik, is there an address anywhere on the building that you reside in?
No.
All right, so what makes that 28890?
That's where the Edison bill is for.
There's a sign, isn't there?
Okay, thank you.
A sign on the road that says 28.
Gentlemen, do either one of you have a question for Ms. Zabik based on my question of Ms. Zabik?
No, Your Honor.
All right, anything else, gentlemen?
No.
No.
All right.
Just be my
So-
argument, Your Honor.
Go ahead.
that My client's been denied her statutory right, at least she says, that she didn't receive a notice to quit, which is required by law. And she says that she never received, whether by mail or posting or otherwise, a summons and a complaint. As you know, our earlier argument was that as soon as she saw a posting on her door, she immediately sought legal counsel, and she came in and had a meeting with me. And so it could be, it could be the type of thing where, due to her visual handicap, she didn't see the original one, or it could be because there's no address on the barn house. It was posted on the main house. I don't know how to explain it other than to say that I think Ms. Zabik's testimony is credible. And I think that she, at least if she's going to be evicted, and Your Honor is quite correct, there's, in terms of not having a lease agreement where she has a right to maintain possession, but she still does have a statutory right to have so much notice so that she can find a new place to live and that she can find a place to put her belongings. And so we would ask the court to kindly make a finding that there isn't good evidence of notice to Ms. Zabik, and therefore set the judgment of possession aside.
Mr. Knappman.
Well, Judge, first of all, obviously, if there is, the court should decide that she somehow didn't get notice of the hearing she defaulted at, then it's just a hearing wherein she really doesn't have a defense that's been presented as to how not to be evicted anyway. So it's just a stall in that regard. And she did get notice. The bailiff posted it on the door, as you have in the proof of service for the complaint and summons. That contradicts what she said. And frankly, at this point, she had the judgment posted. We would ask the court to issue the writ of eviction. There's no reason for it not to be issued.
Well, but Your Honor, in rebuttal,
Go ahead, Mr.
I would say that what counsel calls a stall, I call a constitutional right of due process, and also a statutory right to have notice. People, even if they're not property owners, have a right not to be herded out of places without any notice. And that's what the whole statutory and court rule scheme is, to give tenants a fair chance to know what they're dealing with and to make arrangements otherwise. So this has nothing to do with stalling. Had she had, she in effect has lost 60 days because she didn't have notice. So she's sitting here today, no place to go, no place to take her animals, no place, she realizes that she has to leave. But the point is, since she didn't have notice, if Your Honor finds that she didn't have notice, then we should start the process all over again, or counsel and I should negotiate some sort of further order. But they haven't wanted to talk to me about it, so.
All right. So gentlemen, I'm kind of an out of the box kind of jurist. Mr. Vining, if I grant your relief, all we're going to do is have a 30-day period, then have a hearing where your client has no defense. Would you agree with me?
Well, I think she's entitled. I don't know how long it would be, but probably 30 days, maybe a little bit more. Yes, I agree, Your Honor.
But ultimately, we're going to, if I give you what you're asking for, we're going to get to a hearing where your client has no defense to the underlying claim.
That's true, Your Honor.
Okay, so really what we're talking about is timing.
Yes, Your Honor.
Okay, so I see where we got two issues here. We've got the possession of the rental, what we've been referring to this afternoon as the barn, and we've got all this property that's in dispute as to who owns this equipment. Am I fair to say
Yes.
that's our two main issues?
Yes, Your
And
Honor.
I think from what I heard earlier this morning, Mr. Vining, you're starting a probate action where one of the issues you're going to bring up in probate court is who owns this equipment. is it Mr. Zabik, William Zabik, or is it the deceased Bradford Zabik, correct?
That's correct.
All right, so I think, and feel free to disagree with me, gentlemen, I think we could probably all agree as reasonable, bar number holders, that as far as that property is concerned, probably it should stay exactly where it's at with nothing done to it until the probate court decide who owns it.
And my client is willing to do that.
We would agree to that too, Judge.
All right, so you two guys, I mean, you got enough white in your beard, you guys can come up with an inventory that you both agree on, I assume.
I have an inventory that I'm about to file with the court, and I'm certainly going to send a copy to Mr. Knappman.
All right, so here's what my suggestion is. And Mr. Vining, just so you know, I think I could go either way and sleep well tonight with the notice issue. There's obviously some question about how the two residences are identified, if I can say it that way. But I've got a proof of service in the file that says it was attached to the 28890 address. I don't see any benefit to anybody involved here if I set aside the default and just set it for a hearing down the road. I think, especially because we've got family situation, I think everybody would be better served by having some kind of closure. So what I'd like to do is negotiate a move out date for Ms. Zabik, have an agreement by the parties that the farm equipment, construction equipment, all those things that are in dispute will be there until the probate court makes a decision or the parties agree. And then everybody can move forward, just move on.
We would like to do that, Judge.
Mr. Knappman?
I'd be willing to set a move out date, but it has to be a reasonable one.
I agree. And just so you understand where I'm coming from, because of the questions with the process involved, I think that move out date should be at least 30 days. I'm not going to do a 10-day move out.
Well, Your Honor, our thought was we had earlier asked for more, but if we could have 60 days, she would certainly be out. There's a house that Tracy's looking at.
He wants to give her 30 days to move. And he's
purchase.
asking for 60 days.
She had
2 years.
She had
Okay.
a lot more already.
All right, I can't, Mr. Knappman, I can't, if you're going to have a conference in your office, you got to mute.
Yeah, I know. I'm
Because
sorry.
Mr. Vining's trying to talk and you folks are talking and I'm getting too much.
We would be agreeable to a move out date of February 28th, Your Honor.
And Judge, I think we're looking at 30 days. I think that's appropriate. That's more than enough time for her and her possessions in the barn out. And the tractors and all are going to be staying there. So she doesn't have to worry about that. So she's got some stuff in the house.
What are we talking about for animals, Mr. Vining?
For animals?
Yeah, I mean, are we talking about a couple household pets or are we talking, 30 head of cattle?
There are two large golden retriever dogs. So that makes it more difficult to
Yeah, logistically, it's not the logistics of moving the animals. It's finding a home where she can go and take the animals.
Yes, Your Honor.
Understood. Yeah, understood. A lot of rentals don't take pets. Okay. All right. All right. Anything else, gentlemen?
No.
Nothing for the defense, Judge.
Okay. Have you filed in probate court or you're getting ready to?
I've filed already. I have a receipt indicating that we have a case number, but I have not yet received the letters of authority due to the COVID situation.
COVID.
They're running
Right.
behind. But I
Yeah, I can imagine.
I have a judge and a case number. And
Okay. All right. All right. Go ahead.
I will provide that to Mr. Knappman so that he has it as well.
I was gonna say, he maybe had warrants out.
All right, gentlemen, I'm ready to make a decision unless anybody's got a last minute argument for me.
But it happened here in this court, with marijuana.
None?
None.
All right. Thank you. Gentlemen, I appreciate your professionalism. I'm sure you are, both of you are probably just as reluctant to me as I am to get involved in these family disputes. They're always the worst part of what we do. I think that's probably one of my biggest regrets is that as a judge, I get to make decisions, but I very, very seldom get to do anything that can heal a family rift. So I hate these family disputes. So with that in mind, I'll just wish all the Zabiks good luck moving forward. My judgment is possession for Mr. Zabik. I think probably we should have the case heading show that William Zabik is the actual plaintiff. I think he's the rightful plaintiff with Sandra McGahee acting as his power of attorney. Would you agree with me on that, Mr. Knappman?
I'd be fine with that, Judge, certainly.
Yeah, I mean, as the property owner, I think he's the rightful plaintiff. And I'm going to order that possession will transfer on January 29. So that means the first Monday in February, Mr. Knappman, you can be here to file the writ if that's what's necessary.
Yes.
I also want that judgment to reflect that the parties agree that none of the inventory will move until either the parties agree on it or there's a judgment from the probate court. And obviously, you lawyer types want to put some language in there probably about, not only will it not move, but nobody's going to sugar the gas tanks or otherwise harm anything either.
Very good, Judge. I'll cooperate with Mr. Knappman and we'll get something drawn up.
All right. Anything that we should cover in my judgment, any issues that we didn't talk about that one of you or both of you think might rear their ugly heads between now and January 29th?
No, Judge. I think that's about as far as we need to go.
Me too, Judge. Thank you.
All right. And good luck, folks. Merry Christmas and stay healthy.
Merry Christmas. Thank you.
Thank you, Judge.
I'll look for the order from Mr. Vining.
Thank you, Judge. Your Honor, I'm going to be off until this coming Monday, but I'll have it emailed to you by next Monday.
No, that's fine. Email it to Mr. Knappman and then he can sign off on it if he's satisfied with the language, and we'll get it processed as quick as we can.
Thank you, Your Honor. Merry Christmas.
We're in Monday, Tuesday, and Wednesday next week as well.
Okay.
All right. Thank you, gentlemen.
Thank you, Judge.
But he did. So now, unfortunately, this is out and I call it the barn. It's not really. It's just a facility. It's an archive facility. And I have keys to it and everything, but I can't get in there and look those boxes by myself.
What's on, kid?
I talked to Tommy Coleman and he's just gonna go straight to get the tether on Monday. Do you want me to call Romulus or?
Yeah, if you don't mind. Damien's probably not working any longer, so if he's gone, just ask somebody to leave a message for him.
For Damien?
Damien Hall, Lieutenant Hall. Thanks. And then if you would, you working Monday?
No.
Okay. I'll make myself a note. What's that guy's name? I'm sorry.
Tommy Coleman.
Thanks.
Okay. Well, you can tell them the court's gonna have problems too, because we have a lot of people out, and I can't get out there without. It used to be the work program supervisor with the camper, but I can't get out there without one of the court officers going, they're in those boxes here. So if you just tell him that it'll probably be the 5th, because the 4th is gonna be a very busy day for Judge Oakley, okay? We have a docket and everything that day, and I have to do the Zoom and everything. But I can get somebody to get out there with me later in the afternoon or first thing in the morning on the day.